think they're all at least 1/4 Indian.
I see.
Thank you, gentlemen. The case is submitted. We'll hear arguments next in United States against the Sioux Nation of Indians. I'm just going to keep the names of the ideas, road construction, a product.
That's the.
Then you don't have to
Then you
get
don't
to the
have to get
others.
to the other stuff. Yes, I do.
Mr. Claiborne, I think you may proceed whenever you're ready.
Mr. Chief Justice, and may it please the Court, the case is here on our petition for certiorari to the Court of Claims, which court directed the entry of an award of more than some $105 million to the Sioux Nation in respect of the action of Congress a century ago, to be exact in February 1877, in severing some 7 million acres, the Black Hills area, from what was then the Great Sioux Reservation. Some 88 million of that sum of 105 million of this award is attributable to interest calculated at 5% over 103 years on the principal sum of 17.1 million, which was found by the Commission, affirmed by the Court of Claims, to have been the value of these 7 million acres in 1877.
So I understand that there's no issue here about many things, that the only issue is the issue of interest.
That is exactly so, Mr. Justice Stewart, and that in turn, the issue of interest, the only issue we bring here,
there is a taking condemnation.
Depends entirely on whether or not this amounts to a taking in the Fifth Amendment sense.
Yeah, I asked just in passing then, what does the 17.1 million?
The 17.1 million is the value of the Black Hills area as found by the Indian Claims Commission, as affirmed by the Court of Claims, and not disputed by the United States.
Well, then doesn't that imply that there was a taking?
Not so. It's simply that that was the value of the land. The question before the Commission, left open by the Commission in 1974, was whether there had been, in effect, payment to that extent or to a greater extent, the consideration which was given, an undertaking to provide provisions for so long as the Sioux Nation might need them.
No, it's been decided that there wasn't payment and that therefore the government owes the Sioux Nation $17.1 million for the value of the Black Hills that were in 1877 or whatever the date was.
Yeah.
But if you don't quarrel with that, why doesn't that imply that there was a taking?
Well, for this principal reason, Mr. Justice Stewart, we are, by special act of Congress passed in 1974, forbidden to offset any payments made with respect to this transaction that take the form of provisions for subsistence. But that does not prevent us from taking into account that payment in order to determine whether or not there was a taking. Moreover, the Court of Claims did not approach the question of taking as determined by whether or not the payment was or was not sufficient as it turned out, but rather on whether or not the Congress in 1877 was acting in good faith in attempting to provide a fair equivalent for the value of the Black Hills by making these undertakings, very substantial undertakings, to provide provisions which, as we say, ultimately cost the United States
$100 million.
amounts in excess of $40 million.
Yeah. But, so what was the $17.1 million for?
The $17.1 million is simply the valuation of the land that was severed from the reservation in 1877.
That the government now owes the Sioux?
The government now
nation?
owes it only because, in the peculiar circumstances of a special act of Congress passed in 1974, the government henceforward is forbidden to consider, for the purposes of the award, an offset which takes the form of a provision for food rations.
No, I understand that, but what I have difficulty understanding is, if it wasn't a taking, why the $17.1 million? Now, I can understand your argument if you can say it was taken but paid for. But I don't understand why you can say it wasn't taken at all if you don't quarrel with the $17 million.
Mr. Justice Stewart, we say that it was an exercise of the power of Congress to deal with Indian affairs for the benefit of the tribes. We say that such cases...
No, that what was an exercise?
The Act of Congress of 1877.
Yes.
Just as it was in Lone Wolf
Right.
and in
Well, then,
many other cases.
then they wouldn't owe the Indians anything.
Except for the Indian Claims Commission Act, which provided that, notwithstanding that Congress was exercising its Indian power, if it turns out that the consideration paid was inadequate, or that some duress was involved in the case of an agreement, as a matter of a moral claim, the court shall allow whatever the deficiency be. What is more, as I have said before, Congress in 1974 provided, with special reference to this case, that here, exceptionally, the offset, the payment, if to the extent largely it was, paid in food rations, shall simply not be allowed as an offset. And for those reasons, we are left unable to say, for the purposes of the award, we paid full value, and accordingly must admit our liability unless we dispute valuation, which we do not.
Claiborne, perhaps this is just the same question my brother Stewart has asked, but what is the source of the government's obligation to pay $17.1 million?
Well, in our view, Mr. Justice Stevens, it is the Indian Claims Commission Act and the 74 Act, the 1974 Act.
The Indian Claims Commission Act.
The Indian Claims Commission Act provides that whenever there is a finding that the United States in its dealings with a tribe paid either an unconscionable consideration or was guilty of dealings less than honorable in the transaction.
Well, is it correct to say that the source of the obligation is a finding by the Commission pursuant to statute that there was dishonorable dealing by the United States?
Yeah. Well, it so happens here, Mr. Justice Stevens, that the Commission made no such findings because instead the Commission found that there had been a taking in the Fifth Amendment sense. The first time round, the most recent but the last time the Court of Claims dealt with this case, it said no, the finding of a constitutional taking is barred by res judicata, but we, the court, will substitute a finding that the dealings were less than honorable, and on that basis we will make an award without interest for $17.1 million. And indeed, the United States acquiesced in that determination, and normal course, judgment would have been entered, and the matter would have been at an end. However, the Sioux Nation once again persuaded Congress to make an exceptional rule, and in 1978, the Congress passed an act which directed the Court of Claims to ignore the objection of res judicata or collateral estoppel and to review on the merits the earlier Commission determination that there had indeed been a Fifth Amendment taking. On this third round, the Court of Claims acquiesced and affirmed the Commission's earlier finding of the Constitution that there had been a taking.
I suppose if there, I suppose that is what, that would have been one form of dealing with an Indian tribe unfairly.
Indeed, indeed. Indeed, the only cases in this court, or in the Court of Claims before this one, in which this or that court has found a taking in the constitutional sense, are cases in which this court has found it appropriate to say that an act of confiscation is not an act of guardianship, all cases in which the government gave no undertaking, made no payment, whatever, or the most derisory one. Very different from this case, in which the Court of Claims assumed, though did not find, that the government had indeed undertaken an obligation which in the fullness of time not only equaled the value of the Black Hills, but perhaps exceeded it. They found that, however, to be irrelevant. Irrelevant because they put themselves at the time of 1877 and said, in effect, Congress didn't know it was going to cost the United States that much.
In the Indian Claims Commission Act, is the language dishonorable dealing and that sort of thing, the type of language that would apply between trustee and ward, or trustee and SETI, or whatever you want to call it?
No doubt there is some thought of that relationship of guardian and ward in the terms of the Indian Claims Commission Act. But at least one of those provisions, the one that deals with dishonorable dealings, which is subsection 5 of 25 U.S.C. 70A, expressly allows recovery for claims that would not be recognized at law or in equity, but which, as a matter of moral obligation, ought to be paid, and the Commission is directed to make an award if it finds that as a moral matter, not as a legal matter, the dealings were less than honorable.
This proceeding commences, the Court of Claims case commences with the 1974 Act and rests on that, does it not? That is,
the Court of Claims decision rests on the 74 Act and the 78 Act, more recently the 78 Act, because...
Now, could either of those acts have said this shall be treated under the terms of the Fifth Amendment taking?
Mr. Chief Justice, I think Congress could have, of course, simply awarded the Sioux Nation $100 million or whatever sum in the discretion of Congress that was thought to be fair. I don't think that Congress could direct a court to bend the rules of the Just Compensation Clause and hint that they were acquiescing in an award under the Fifth Amendment. I don't think Congress could have found a violation.
You think Congress could not have declared against the whole background that this was a taking and should be now evaluated on the basis of just compensation? That wouldn't be tinkering with the Fifth Amendment taking clause, would it?
Well,
It'd be declaring that it was a taking.
Mr. Chief Justice, that may have been possible. I have difficulties...
That would have been a private bill, wouldn't it?
Well, but I think the Chief Justice is suggesting that the court still had a role to play, and whether the Court of Claims as an Article III court could be simply required to make a valuation determination accepting as a legal matter directed by Congress that the Fifth Amendment had been violated, I'm not sure whether there'd be separation of powers.
If the Indian Claims Commission and the Court of Claims, each of which is a creature of the Congress, could declare this was a taking, why couldn't Congress have resolved that question in the 74 and 78 Acts?
Well, Mr. Chief Justice, perhaps they could have. Clearly they did not.
Well, is that important, that they did not?
It is important that they purported to leave it entirely to the court to determine under the usual rules whether or not this amounted to a taking in the Fifth Amendment sense. And any side hints thrown out properly disregarded.
And in that process, it would not be a taking as of a contemporary taking. It would be a determination of whether there had been a taking back in 1868 or 77 or approximately 100 years ago.
Indeed, Mr. Chief Justice. Now, I find that my time has run to the point where I must be very brief about the background facts of the case. The difficulty in the case arises because in 1868, when the Sioux Nation severed or relinquished a large part of its territory, it was provided, among other things, that no further cession should be accomplished, should be valid, except with the concurrence of 3/4 of the adult male members. That treaty in 1868 had made a number of provisions which were designed to encourage, to furnish incentives by way of money and material aid to the Sioux to become farmers. However, it had wholly failed in that respect. And shortly after the 1868 treaty, the background situation against which this transaction must be judged included these elements. The first, gold reports had come that the Black Hills were rich in gold. Those reports had begun as early as 1868, and indeed some miners had intruded that early. Gradually, the invasion multiplied. There were, concededly, serious governmental efforts to prevent the miners from intruding and indeed to remove them from that area. Those efforts are continued between the date of the treaty in 1868 and the end of 1875. They were, however, largely unsuccessful. No doubt the greed for gold exceeded the fear of the soldiers, and the invasion of the miners became, in effect, unstoppable, at least without dedicating the entire army resources to that single purpose.
Certainly that exchange of letters between General Sheridan and General Sherman were of profound interest as to how serious the government attempt to prevent the miners' influx was.
Mr. Justice Blackmun, there is that exchange which suggests that in the view of one general, the president might wink at some invasions. On the other hand, there are concededly instances in which the army did arrest, did remove, did incarcerate miners who had penetrated into the Black Hills. It's a matter of timing. Toward the end of 1875, the president had determined that this was an impossible policy, and he eventually abandoned it by withdrawing his orders to the troops, though he did not publish them in November 1875. Now, another aspect of the background of the case is the conceded dependence of the Sioux on governmental food rations. As I've said, the Treaty of 1868, which had sought to make the Sioux self-sufficient farmers, had entirely failed. The Sioux in 1875 and 6 and 7 were still wholly dependent on the government for rations, the government expending something over $1 million a year for that purpose alone. The Sioux Treaty of 1868 had provided that rations should continue for 4 years. But gratuitously, without any legal obligation, the Congress had continued those appropriations for 2-3 years more. And Congress was unhappy with the prospect that that situation might continue indefinitely. After all, guardian though it was, the guardian is not normally expected to put his hand in his own pocket for the sake of his ward. Another consideration that is an important background of the case is the value of the back hills to the Sioux themselves. They knew there was gold there, but they had no intention of removing it. There was no large game in the reservation. This was not the hunting ground. There was valuable grazing and agricultural land, but it appears that it had been put at this period to very little use by the Sioux. And finally, because of the miners coming in, there had been clashes between the miners and the Indians, and there was the prospect that that armed conflict between those two forces would escalate. In these circumstances, Congress determined, after much patient consideration, that the only practical, the only realistic solution was to persuade the Sioux to cede the hills, and that determination in the mind of the executive and legislative branches of the United States had occurred by the beginning of 1875. The President had the area surveyed with a view to determining its value so that a fair equivalent could be paid. He invited the Sioux leaders to Washington. He appointed a commission. That commission, the Allison Commission, failed. This is all in 1875. Upon the failure of any agreement, Congress considered the matter, and while it is not really relevant to determine precisely what threats were made about cutting off rations, since this is not a case based on duress, it is nevertheless important to note that Congress at no time ever cut off the rations, and indeed never threatened to cut off the rations except a year hence. At all events, a new commission was formed. That commission ultimately reached an agreement with the Sioux leaders, albeit the requisite number of members did not sign. That agreement, later ratified by Congress in the 1877 Act, provided relevantly in Section 5 that in consideration, and those are the words of the agreement and of the Act, in consideration of the cession of the hills, several undertakings were made by the United States, the important one of which was a promise to provide rations for so long as the Sioux might need them. Congress was well aware that it had just appropriated in the preceding years over $1 million. It had deleted a provision that rations should continue for only 10 years more. This was entirely open-ended. Congress was obviously aware that it was undertaking a very substantial burden.
What did it amount to over the period of years? Is 50 million the figure you have in the briefs?
There is a figure of 57 million, which is based on General Accounting Office reports once upon a time conceded by former counsel for the Sioux, which we, however, cannot say is any longer conceded. There was a finding by the Court of Claims itself in 1942, when this case first reached that court, that as of 1942, the total amount had been some 43 million. Even allowing for discount, considering that the payments in the first 20 years exceeded or averaged something over $1 million a year, it is evident that the United States not only paid interest, but repaid the principal long before 1942 or the present. There is one irony about this case, which is that the question of taking would not be here at all if either the 68 Act had not provided that the signature of the Sioux leaders was not sufficient, and this had therefore become a proper treaty, or if they, 3/4 of the members, had been persuaded to sign. Because no matter what duress, no matter how unconscionable the consideration, no matter how dishonorable the dealings, no court has ever found a taking when there was an agreement. compensation may be due because advantage was taken of the Indians, and they're entitled to an award for the difference, but not for the interest. Had Congress been as high-handed and as callous as is suggested here, that result, no doubt, could have been accomplished. After all, the dependence of the Sioux on their rations might have informed a callous executive and a callous Congress to simply wait until such time as the Sioux, having been cut off, which they never were so desperate that they would indeed sign. There would then have been an agreement. Indeed, an irony here is that the Sioux, who in a companion case involving the 1868 treaty have recovered, subject to offsets, something over 40 million, on the ground that they were grossly underpaid, much more grossly than here, will not receive interest on that award.
Mr. Claiborne, on this 40 million and 20 million and all, how much of that was administration cost?
No, Mr. Justice Marshall,
You know, we know what happened back in those days.
the accounting reports are exhibits before the court, but those figures were calculated as the amount attributable to the subsistence obligation undertaken in 1877, and quite independently of the obligations which continued under the 1868 treaty.
But was that the money that the Indians received? Or was some of that administrative cost?
We know that the procedure with respect to the rations was to bring cattle onto the reservation and there be held until such time as they were slaughtered and distributed. 1.5 pounds per person per day of beef was the, in gross of course, was the requirement of the treaty. The treaty was not vague with respect to these provisions. It specified exactly 1 pound of flour, 1.5 pounds of beef, and so forth, per day, per person. To what extent some of those supplies may have gone astray, I cannot testify. Now, we believe that the Court of Claims went astray in two respects, and I must be prompt. First, we think the Court of Claims, applying its own good faith test, presumed the wrong way. It should have accorded to Congress the presumption of good faith, as the Lone Wolf case teaches us. Rebuttable presumption if the evidence is overwhelming to the contrary, of course. But instead, the Court of Claims relied on the failure of Congress expressly to say, we are hereby granting a fair equivalent. They did say, this is in consideration of, we must assume they meant a fair consideration. Now, secondly, it seemed to us that the Court of Claims too narrowly focused on the question of monetary equivalence. The United States, as guardian, is not merely a land manager. It has broader duties, and in the special exigent circumstances with which it was faced here, it may have been in the interest of the Sioux to acquire, even for less than full value, this land relatively useless to them, in order to avoid all the dangers, including the danger that that land would be lost to the miners for nothing, including the danger that if they did not sell it, if it was not acquired, they would be without rations, including the danger that hostilities between them and the miners would endanger the future of the Sioux Nation. I may reserve the balance of my time for a while.
Mr. Claiborne, could I ask you one question? Focusing on the 1978 statute, where the Congress enacted legislation that, as I read it, effectively overruled the Court of Claims' earlier holding that the taking claim on the part of the Sioux was barred by res judicata. Does that bother you at all? You don't make the argument. Is that conceivably a violation of the separation of powers doctrine?
I would have thought not, Mr. Justice Blackmun. I hesitated in answer to the Chief Justice's question as to a congressional finding of taking, but I think Congress is entitled to say you may have another opportunity to litigate your lawsuit.
Mr. Lazarus?
Mr. Chief Justice, and may it please the Court. The issue in this case is whether the Act of February 28, 1877 effected a taking of the Sioux Black Hills country in violation of the Fifth Amendment, for which just compensation must be paid under the Constitution. It is the Act of 1877 that effected the taking. Government counsel has alluded to the possibility of an agreement, or maybe the United States could have gotten an agreement, or it could have forced an agreement, but it didn't. It enacted the 1877 statute, and it is the statute, not any agreement, that took the Sioux land.
Was it the 1974 or 78 Act that said that there would be no set-off for the 50-odd million, more or less, that was paid? Which of those acts?
It was the 1974 Act which said that food, rations, and provisions may not be deemed payments on the claim. But the government gives less to the 74 Act than the Act really encompasses, because the Indian Claims Commission had determined that whatever the government spent on rations was a payment on the claim, and therefore it was wiped out by the 74 statute. Congress has taken that whole claimed amount of money out of this case.
Now, having done that, could Congress also have declared that the Court of Claims should proceed as though there had been a Fifth Amendment taking in back there 100 years ago?
Congress could have done so, Your Honor. But when I testified before the committee, I said the taking was so clear that Congress did not have to go that far. All they had to do was waive res judicata, and the Sioux were going to win this case.
Well, a couple of lines in that statute, and none of you would be here today.
I think that's true, Your Honor. And I think if we weren't talking about 105 million, none of us would be here today either, because this is a clear-cut case of a taking.
Then what was your objection to having the Act declare that?
Oh, I'm not sure I could have gotten the committee to go that far, Your Honor. What they did was waive res judicata and give us our day in court. And we told them if we got our day in court...
Your second day in court on the question.
Well, the first day in court was on food, rations, and provisions, where Congress made a different kind of finding. Congress said
well, your
that...
first day, though, on the taking issue was some time ago.
In 1942, the case was litigated under a special jurisdictional act. And the case was then dismissed, and the basis for the dismissal was a matter of dispute when we were before the Court of Claims in 1975. We said it was dismissed because it was not within the scope of the jurisdictional act. The majority of the court said otherwise. But in any event, even that majority described the 1942 decision as whether rightly or wrongly decided it's res judicata. They had their doubts even then about the correctness of the 1942 case. And of course, Congress in 1978 has told us that 1942 case is washed clean. We consider this case now on the merits.
I take it if when Congress took this land, as you say it did, instead of promising to provide rations and subsistence, it had established a trust fund of X $1 million and said we out of the income from this or the we will use to pay rations. Would the case be different? I suppose it would.
Oh, yes, it would, Your Honor. If Congress had made a payment in 1877...
Or established a fund.
The fund could be the equivalent of a payment. If it had, because that's the way Indian money was treated. It was never given directly to the Indians. It was put in the Treasury to their credit.
And if they had promised to set up the fund and use that to buy rations and distribute them, you wouldn't be here, I guess.
If Congress had in fact set up that fund, I would not be here. If Congress had made an indefinite promise to say, we'll give you $17.5 million at some indeterminate time in the future to some indeterminate number of Sioux, that would not be just compensation. Just compensation is payment.
Well, it might, in amount it might be, but you say that would not have avoided being a taking. Then.
That is correct. That would mean the 1877 Act was a taking.
Was a taking rather than an exercise of some other kind of congressional power.
And that is exactly what happened in 1877.
Now, Mr. Lazarus, is the taking issue an open one in this present litigation?
Well, it is...
I don't mean how you feel about it, but I mean whether it's barred by some previous decision or barred by the jurisdictional acts of Congress and...
Oh, no, the taking issue is the critical issue. That is the one the 1978 statute opened for the court. That's the only issue before the court. But when you say, is it an open issue, it is not open in this sense. The government will concede that under the circumstances of the 1877 Act, there would be a taking if that property were owned by a white man. All they are saying is it's not a taking because it was owned by an Indian tribe.
Well, but that would be the same. It would be the same thing, I suppose. In my example, the Congress couldn't do that to a white man.
Congress could not do it to a white man.
And it would have been a taking.
It would have been a taking, and it is a taking for an Indian.
Yeah, well, the only reason it's a taking for an Indian here, though, is because they didn't put up the fund.
Well, if
they just made an indefinite promise rather than put up the fund, so it was a taking.
That is correct.
But that isn't the reason why it would have been a taking for a white man.
Yes, if it had been a taking, if that property were owned by a white man and Congress took it and paid him, they would have to pay him.
It wouldn't be enough to set up a fund.
That is correct. That is correct.
What if Congress had simply said, instead of trying to take back the 800 square miles consisting of the Black Hills, we have a lot of demands on our resources, and our army can't protect you, Sioux tribes, but we concede it's your property, and you fight off the individual white citizens that come in looking for gold as best you can.
Well, that would have been allowable self-help, except under the 1868 treaty, the Sioux had promised to maintain peace. And the Sioux did maintain peace, and it was the United States that broke the peace. It was the United States that sent Custer on the reservation to publicize that there was gold. As soon as the gold was publicized, the whites invaded the reservation. That was a violation of Article 2 of the treaty.
But now, what if the invasion had been simply by white citizens having no connection with the government?
The government had a treaty commitment to keep them out. Under the 1868 treaty, the United States promised to keep whites out of the Great Sioux Reservation, and it had a military obligation to do so. Now, it turned out that government counsel says we have conceded that the United States made serious efforts to keep the whites out. We have conceded no such thing, because the finding of the Indian Claims Commission was that the military forces, whether because of inability or unwillingness to keep the whites out, allowed them in.
Do you say that the construction of the treaty made it an absolute obligation to keep the whites out, no matter what the demands on the federal treasury or no matter what Congress would have appropriated?
Yes, until the United States changed that treaty, that was its obligation. And I would point out to you, Your Honor, that the United States always found enough troops to round up Indians. Its only trouble was finding enough troops to round up white people.
Well, to take the situation of, say, something completely divorced from Indians, of a local county or city government, and if it were to devote 90% of its tax dollars to increasing the police force, it could prevent any burglaries. It instead has any number of demands on those resources, and so it only appropriates 20%. Therefore, there are burglaries in the area which depreciate the value of the property and put pressure on people to sell, perhaps. Now, does that amount to a taking?
Your Honor, let us assume you're hypothetical. First, the United States created this crisis. It wasn't the Indians who created it. It was the United States who created it. The United States took the bulk of the Sioux land under the 1868 treaty, and as Government Counsel has already pointed out, paid them $40 million less than the land was worth. As a result of that, they started impoverished. That was the fault of the United States. Then the United States kept them from their hunting grounds, so they became dependent on the United States for food. Then the United States first encouraged the miners to come in and then withdrew the troops. Then the United States rounded up the Sioux and put them on the reservation and took their guns and horses so they couldn't hunt. And there we had this crisis that the United States created. Now let us assume the United States didn't have enough money to handle that crisis other than to take the Black Hills away from the Sioux, which is exactly what it did. All we say is, okay, pay us. And that is what the United States did not do. All the United States had to do was to pay us the $17.5 million that the land was worth. And it made absolutely no effort to do so. And it hasn't done it yet. And I think, Mr. Justice Stewart, you put your finger on it right at the beginning, because the government concedes it hasn't paid us. And it concedes it owes us under some theory under the Indian Claims Commission Act. That can either be for a breach of trust, for failure to pay a conscionable consideration, or for a violation of fair and honorable dealings. The gravamen of each one of those causes of action is you didn't pay us. And if you didn't pay us for those causes of action, you didn't pay us for a taking either.
Suppose the government had, at the time that the Black Hills were taken, as you say, the government had said, well, let's agree on a value and we'll pay it to you over a period of years. And they had agreed on a value, say $20 million, payable over 50 years. Would that have been a taking?
No, sir. That would have been an agreement. If the Sioux had agreed to it, even if the amount of money was not fair value, that would not have been a taking.
Or if the government had said, what if the government had said, we think the value of the land is $20 million and we'll pay it to you over 50 years?
If the Sioux had agreed to it...
the Sioux didn't agree.
The rule in just compensation cases, as I understand it...
Well, what about the rule in fair compensation cases where the government is saying, look, is arguing this is not a taking. We're taking the land under our other, with our other hat on, but we're paying you fair compensation.
This court has already disposed of that argument in the Creek Nation case, where the United States made the argument that we were not dealing with them in our sovereign capacity, we were dealing with them as a trustee. Mm-hmm. And this court made very short shrift of that argument. It said, you are responsible as a trustee and you are responsible under the Constitution. And your activity as a trustee must conform to constitutional standards. And the court there found, even though the government argued that it was acting as a trustee, that it was a taking because the United States...
I thought you said a while ago that the United States had set up a trust fund of $20 million here and paid the income of it to the Sioux. It would have been all right.
Well,
it would not have been a taking.
It would not have been a taking in the if that $20 million fund had been equal to the value of the
Well, I
land.
assume that. I'll assume that.
I thought you were assuming that. And what I am saying is that that's the exact same situation as if the United States had paid the $20 million directly to a white owner.
And then it wouldn't have been a taking even though the Sioux had not agreed to it.
That is correct, because just compensation would have been paid.
Well,
But in this case, just compensation was not paid.
And if the United States had said, well, we were thinking of setting up a $20 million and paying the interest to you, but instead of doing that, we're going to pay you what will undoubtedly be more than that in the form of food and shelter. Then it's a taking.
Then it is a taking, because the cases are quite clear that just compensation is payment, not promises. The
But
government.
it's also quite clear in an ordinary takings case that what compensation is just cannot be unilaterally determined by the taker. And in my brother White's questions to you, you conceded that had the United States simply unilaterally determined that $20 million is the right price, we'll set up a trust fund for that would not have been a taking.
If that is how my remark is being interpreted, it goes too far.
That's why I understood your answer.
Oh, no. My answer is that if that $20 million were determined by a court to be just compensation, as the Commission has determined that 17.5 was just compensation, then just compensation would be paid. But if the value of that property were $25 million and Congress said, we'll set up a trust fund of 20, that is not just compensation, and that no matter how much good faith is involved, that is not just compensation. This court in Monongahela Navigation 90 years ago said, it's not up to Congress to say what just compensation is. The courts say what just compensation is.
Well, I agree. I think you said that if the government set up a fund, that it itself determined was a fair compensation and paid the interest, that would not be a taking as long as whenever the question came up, it was determined that was fair compensation.
That's correct. That is correct.
Although the Sioux might at the time have objected to it violently.
Now,
Mr. Lazarus, how many Sioux are there now?
Your Honor, there are 60,000 or more Sioux now. They are at the very bottom of the economic ladder, even compared to other Indians. The Sioux are among the most depressed in the entire United States. And they are so depressed, not in least part, because the United States in 1877 took their most valuable asset, the Black Hills, and it hasn't paid for it yet. Now that land, which the United States acquired and turned over to its assigns, $1.4 billion in gold has been taken out of the Homestake mine alone. That's just one mine among many.
But the Sioux never wanted it to mine, did they?
It was the Sioux to do with as they wished, Your Honor, under recognized title, which they possessed. They had a title as sacred as a fee. They could use it or not use it. They might not have wanted to use it in 1877. They may have wanted to use it in 1910. The standard of value is not the value to the Indians. It is fair market value. And if they wanted to use their property for hunting at that time and for gold at a later time, that was to be their choice, not the government's choice. The government had no right to take it away from them just because the government didn't like the way they were using it. Now, I would like to point out, Your Honor, because we have talked a great deal today about money, so I would like to address the 47 million or 43 million or 57 million that the government repeatedly raises in its presentation, both in its brief and on argument here today. I regret to say that what Government Counsel has told you about that money is just plain inaccurate. He has not accurately described what is before the court. What is in the record in the court is a General Accounting Office report that lumps as Mr. Justice Marshall recognized, that lumps a whole series of expenditures under a label 1877 Act. And it doesn't tell us whether it was for provisions, and it doesn't tell us whether those provisions were ever delivered, and it doesn't tell us if those provisions were delivered, did it go to people who weren't entitled to them? Because the Act says that children between the age of 6 and 14 don't get rations if they're not in school. And it doesn't tell you whether those rations were delivered to people living on land susceptible of cultivation and their families, because they weren't entitled to rations either. So none of those things could be counted in the $43 million. The $43 million includes money that was spent in 1875 and 1876 that couldn't possibly be consideration under the 77 Act. There is not, in our brief shows, a bit of credible evidence that the government spent 5 cents for rations on the Sioux. But even if it had, even if it could prove that it spent every dime of that $43 million, it would be irrelevant for purposes of this case, because whether there was a taking depends upon what the 1877 Act said, and it has nothing to do with what may have happened 10, 20, or 50 years later. The 1877 Act makes no payment to the Sioux. All it does is make them a conditional promise. We'll provide rations for you until you can support yourself, subject to these various conditions about children not getting them and laborers not getting them. And that kind of indefinite promise is not just compensation, and the government concedes that it's not just compensation.
If pursuant to a treaty, a reservation is set up for an Indian tribe, and sometime later the Congress just says, well, we think the reservation is too big. We're just going to cut it in half and open the rest up to it. So it just cuts it in half and redraws the reservation. Now, is that both a breach of the treaty? Is that a breach of the treaty, or is it a taking, or both?
It is a breach of the treaty, and the United States has the power to breach the treaty.
That's Lone Wolf.
That's Lone Wolf.
Right.
Lone Wolf tells us that if Congress determines that reservation should be cut in half, Congress can come in and do it. It can do it without the consent of the Indians, and it can do it in violation of the treaty. It is also a taking, and when Congress does it, it has to pay for it. There is no reason...
Now, what case is that?
That's Shoshone case, that's Klamath, that's Creek Nation, that's every case this court has had where we have dealt with just compensation and recognized title.
But those were cases just involving whether interest should be paid.
Well, that's what this case involves, Your Honor.
But I thought this involved a taking, too. Did those expressly involve the question of whether Justice White's hypothesis was or was not a taking?
Those cases all involved taking. The circumstances were different. In the Shoshone case, the Shoshone had a reservation. The United States settled the Arapahoes on part of the reservation. The Shoshone never agreed to it. Question, did the United States have the power to do it? Yes. Did the United States have to pay for doing it? Yes. Did it have to pay just compensation? Yes.
So
That's
a treaty-created property right is a property right that if it's taken by the United States, they got to pay for it.
That's right. A treaty protected. We're only talking about recognized treaty title, not aboriginal title. But recognized treaty title is Fifth Amendment property under the Constitution.
Well,
that's what this court held in Shoshone.
That's a little different in this, you tell me if I'm mistaken, from an Indian reservation in which title remains in the United States government.
Well,
And the question, such as in the Dakota case and others, as to whether or not the reservation has been terminated is a question of congressional intent. But here, this was not an Indian reservation. This belonged to the Sioux Nation, didn't it?
well, this was all reservations the beneficial ownership and all the incidents of ownership are in the Indian tribe. The bare legal title is in the United States.
And that was true here, too?
Yes.
It was.
Yes.
This was more than Aboriginal title. Even if originally it had been Aboriginal title, it was recognized by treaty and it constituted a reservation.
That is correct. It was recognized by treaty twice over.
It was federal land.
It was a federal Indian reservation, recognized title, and
I
that
thought title was in the Sioux Nation, not in the federal government.
well, all of the incidents of ownership. If you want to say who has all the incidents of ownership, it is the Sioux Nation. Where does the bare legal title rest? It is in the United States, as it is with respect to all Indian lands. That's part of what establishes the trust. But when the United States takes it, and Shoshone made this quite clear, when the United States takes it, the Indians have a 100% interest for purposes of determining just compensation. You value it at full value.
Has there been any question of compensation in the cases before this court where the question was the reservation terminated?
No, I don't think we get the just compensation cases in that situation unless you have a statute, what we call the surplus land statute, that was in Decoteau and Rosebud and Matz against Ornette. Where there is a surplus land statute that the Indians have agreed to that terminates part of the reservation, there's no just compensation claim. There may be a just compensation claim if it is a unilateral surplus land statute, and the United States takes these surplus lands and disposes of them to settlers, to white settlers, for $2.50 an acre when there's really a value of 10.
But if all the land in a reservation is either allotted land and held in trust by the United States, or it has been entered and it's in fee ownership of whites. If all the land in the reservation is either allotted land or it's fee owned by whites, terminating the reservation is not a taking.
That is correct. Yeah. That is correct. Just changing the jurisdiction is not a taking. It is acquiring the land, which what happened in this case, that creates the taking. Now, Your Honors, I see my time is almost up, and so all I can say is that if the precedents of this court are followed, then the decision of the Court of Claims must be affirmed, because the precedents of this court say that the Sioux had recognized or a treaty title, that title is Fifth Amendment property, that the United States acquired the land under circumstances that constitute a taking, and my client has never been paid just compensation. And I suggest to you, Your Honors, that you should not think of the amount of money involved. The Constitution is not only colorblind, it is dollar blind. And we are entitled to just compensation under every single ruling of this court, and the Court of Claims should be affirmed.
So if the United States at the time had said, look, we're taking the Black Hills, we're going to pay you $100,000 a year for as long as we want to, but we won't tell you for how long. And they'd paid him $100 million, you would still be making your very argument.
Absolutely, Your Honor, because that was not just compensation.
Can I ask just this one question, Mr. Lazarus? Your position, as I understand it, your basic position, does not require us to consider the issue that the Court of Claims devoted most of its attention to.
Your Honor, our basic position is that you do not have to reach the rationale of the Court of Claims, because there is the good faith test, in our opinion, is not a valid test. If you apply the good faith test, as the Court of Claims did, we win anyway, because they said there was no good faith.
We'll resume there at 1 o'clock, counsel. Mr. Claiborne, you may proceed.
Mr. Chief Justice, it ill behooves the Sioux Nation, who have, at least since 1920, been very much the special favorites of the laws, to put themselves in the shoes of a white claimant who would not be here, having been barred by limitations, res judicata, or estoppel by the admission of counsel, set off.
Sorry, Mr. Craven, I have difficulty hearing you.
A white person in the same shoes would not be here, having been barred by limitations, by res judicata.
Well, unless he were the beneficiary of this same act of Congress.
Yes. But most important, he would have been able to plead payment, as indeed we are free to do, though not to defeat the award of 17 million, but to determine whether there was a taking. The Court of Claims in this case was very clear about that. They held that although the provisions supplied were not allowable as an offset against the award, they were to be taken into account in determining whether there was fair dealing or whether Congress acted in good faith. Now, whether Congress acted in good faith depends on whether, at the time, the value of the provisions was thought to be somewhat equivalent to the value of the Black Hills. The value of the Black Hills is a matter which a century later gave rise to enormous controversy. Before the Commission, experts varied between less than 5 million to more than 25 million. The Commission, after months of hearings and with years to ponder, came up with a figure of 17.1 million. But Congress cannot be faulted if, in 1877, it did not accurately know that value. It would still have been acting in good faith if it had somewhat undervalued the value of that territory. It certainly cannot be faulted because, in fact, its promise was overgenerous. And as to that promise and its implementation, my learned friend has suggested that the figure of 43 million is confected. It comes out of the Government Accounting Office reports. It is a finding of the Court of Claims in 1942. It was increased by an admission of former counsel in the 1950s. It is not a figure taken out of the air. It is well known, and was then well known, that this obligation would exceed some $1 million a year. Congress had deleted the limitation of 10 years, obviously anticipating that it might need to be continued longer. At the very least, Congress undertook a very serious, substantial obligation, which was fully fulfilled, and it ought not now to be said to have been acting in such bad faith as to constitute an unconstitutional taking.
You say that if the government takes the Black Hills and says, we promise to pay you $100,000 a year forever to the Black Hills, obviously you say there's no taking.
Exactly so, Mr. Justice White.
So you don't think the necessary precondition is that at the time the property is taken, that a total value be set and paid over?
Not in such a case as this. To delay for valuation would have simply invited the hills from being stolen for the Sioux and perhaps later acquired when the gold had gone for far less.
It would have been a taking vis-a-vis a white.
In the case of a white man, perhaps the amount must be qualified.
If a group of white people had owned the White Hills and the government had done this to them, that would have been a taking.
I think not, in light of the actual payment that was made
really?
In subsequent...
The government can take property and say we don't need to pay you over the present value of it. We can just...
It may have been a taking. There would have been
$100 a year. Sooner or later, we'll get to the value.
I should correct myself, Mr. Justice White. In the case of a white person, in which the obligations are different, this might have been a taking, but there would have been no recovery because the payments made in respect of that taking, properly discounted, would have eliminated the principal, and therefore no interest would have been accrued.
By the time the money they paid out equaled the principal plus the interest up to that date.
Indeed, as by my computations, that had occurred at about 1915, certainly by 1926.
I'm not entirely clear on this, Mr. Claiborne. Is there any relationship of sovereign to sovereign between the United States and any group of white people within our boundaries?
I think...
And The United States is not and never has been a trustee for any category of white people, have they?
That is so.
Comparable to the Indian relationship?
But that trustee relationship, Mr. Chief Justice, carries both obligations but also unusual powers. The power to dispose against the will and without exercising the power of eminent domain.
There is no such power, comparable power, over any white category.
That is so.
And these were all results of treaties in the first instance, were they not? These rights and duties and powers.
Well, this court has held that independently of treaties, the inherent situation of the Indians placed them within the protection of the United States.
The Constitution itself recognizes Indian tribes as sovereigns, does it not?
Yes, but the Constitution perhaps also recognizes the dependent status of Indian tribes, their inability to alienate their land, which accordingly, if it must be done in their interest, may occasionally have to be done against their will by their guardian.
There's one question, I guess perhaps we've covered, but I just want to be sure. Going back to Mr. Justice Stewart's very first line of inquiry when you first started your argument, I'm not clear in my own mind why, if there is the good faith or its equivalent that on which your position ultimately rests, what is the justification for the $17 million principal award? How can the two be consistent?
Well, Mr. Justice Stevens, the Court of Claims has not taken its mandate to find a recovery only when the dealings were less than dishonorable, literally. They have found that in every circumstance in which the amount paid was less than a substantial equivalent, even though in good faith the bargain was made, there will be an award under the Indian Claims Commission Act. In this case, the Court of Claims determined on its own, without benefit of any finding from the Commission, that the dealings had been less than honorable. The United States, at this point, could not in any event make any offsets. Accordingly, perhaps we could have contested that finding, but we were content, as we then thought, to pay the $17 million and have done with this protracted litigation. Had we known that at the end of the day Congress would reopen the matter of interest in 1978, perhaps we would have contested the finding that the dealings had been less than honorable. But it was not seemingly necessary to do so then.
But is it not correct that the acceptance of your position requires us to adopt a view of the case which would be inconsistent with the $17 million principal award if that were still open?
I think not, Mr. Justice Stevens. I think the court can find that the dealings were not wholly honorable and that results in a moral claim which would not bear interest, and yet find, because that is judged from hindsight, right, and yet find that Congress was in good faith seeking to benefit the Sioux tribe at the time, and accordingly there was an exercise of the Indian power and not of the eminent domain power, and accordingly no taking within the meaning of the Fifth Amendment.
My basic concern, which prompted me to ask you that question or those questions at the outset, was that I had difficulty in constructing any theory if one begins with the proposition that the United States owes the Sioux Nation $17+ million. I'd had difficulty constructing any theory to support the view that the United States didn't also owe interest on that amount. But I think I now understand your answer, which is that the $17 million resulted from the action of Congress that disallowed any offsets.
Exactly so. Indeed.
And that is inapplicable to the question of interest.
When the Court of Claims made its decision in 1974 saying the value of the Black Hills is $17.1 million, it then said in Stage 2 the United States may prove its offsets, including these provisions.
Right.
At that point, the Sioux, realizing that the offsets would wipe out the award, came to Congress and said, forbid that, which Congress did.
In 1978.
And that produced this peculiar situation.
And that produced this 17 million.
That produced the 17 million, which we could no longer contest.